24. Unfortunately, Matt's dad has passed. Mom has, in addition to her home, has a cottage. And the question is, should we do an LLC? Exactly how exactly should we handle Matt getting the cottage? And the answer is by, first of all, because mom's still alive and has control over the trust, what we want to do is when the cottage, and this is true of any property, when money, whatever, when it goes to the beneficiary, to the person that you want to get the money, you should put it in trust for the beneficiary. Now, you can let the beneficiary, if you want to, you can let the beneficiary just empty it whenever they choose. This is not a question of, do I trust my kid? Okay, that's not the deal. The question is, do you trust the world to be nice and safe and sweet and kind all the time? Well, you can if you want to. I wouldn't advise it. So by putting it in trust to the beneficiary, to Matt, okay, now if Matt gets into a rough patch, at least the cottage is not at risk. Now, here's the problem with the cottage being for Matt, and that is, and the trust does provide some protection this way. But we always say, well, look, let's put the LLC around the cottage as well, because that will restrict any liability to the cottage itself. Unless you're the one putting sticks of dynamite under the cottage. Well, please don't do that. But any, you know what I'm saying? Doesn't prevent you against, running your truck into the cottage and killing all the kids or, no, do a Freddy Krueger or something. It doesn't protect you there. But from the usual things, right? Now you're protected. So you got it coming and going. Now there's a couple of tax aspects.
The LLC,
go ahead.
Does it also offer, so, the cabin's on some property and we can sell timber and we can lease some land to farmers? I mean, we could potentially, rent the cabin out. Mm-hmm. Does that offer an opportunity for a family business that can also be used as, tax write-off? So we want to build a barn out there. Can we build a barn and depreciate it, and show it as a loss year after year?
Yeah, because what you do then, what you don't want to be doing is you don't want to be paying, and I hear this from time to time, oh, if I have it in a trust, if I leave it in the trust, I'm going to pay a very high rate of tax. And the answer to that is, unless you do what's called a K-1 to the beneficiary. You're the income beneficiary of the trust. So you want the asset protection part of it. So that's why you leave it in the trust and the LLC. At the same time, you don't want to be paying the super high rates of tax, which is just the ordinary income tax. It's just, instead of getting there at the 300,000 mark, you get there at I think it's 14 or 15,000 mark, something like that. So you get there very quickly to the high tax brackets if you're a trust or an estate. But that's okay, because you do this thing called, it's like a 1099, and you just distribute that to the beneficiary, which would be yourself. Okay. So, it's the cost benefit's not, is very, is what you're looking for there. And do you have to file a tax return on the trust? Yes, you do. Sure. But the LLC itself should be a pass-through, and then so you wouldn't file an LLC on that because you're just doing it for the asset protection, and then away you go. So you can still do that. The other thing is, rather than have, how long have your folks had the property, if I could ask?
25, 30 years.
Okay, so there's been, I think it's fair to say, there's been a significant run up in value. Okay.
Sure,
so
absolutely.
All right. So what you want to do is you want a way to maximize. Here's the deal. When you inherit property from someone, you are treated as if you paid fair market value for the property on the person's date of death, or what they call the alternative valuation date. Okay. So right now, if mom just gives you the property, you're treated as if you paid what mom and dad paid for it, with a half step up because dad passed. Okay. But you're still but you're still being treated as if you're paying 1995 prices on the bulk of it, on half of it anyway. Okay. Well, why not just wait till mom passes? And when mom passes, then you inherit it. Now you're getting the 2050 value to depreciate, right? To take against the, put a barn or whatever, run a business or whatever. Now it's rental property. Now you can depreciate it from that higher thing. And if you decide to sell it, again, you're selling it, but your price is locked in at this much higher price if you ever did decide to sell part of it or what have you. Okay.
Sure.
So you want to inherit. Okay. Now here's the other thing that I would suggest you should be thinking about. What if mom needs long-term care? Okay. So the fact that mom and dad, let's say mom and dad have $1 million, and you say, well, I'm not worried about long-term care. Mom and dad have $1 million. Well, I say, I've seen people go through 2 million, 2.2 is the record that people went through before they got broke in long-term care. And that was years ago. And we weren't paying $16,000 a month for 12 to 16,000 a month for long-term care the way we are now. So you got to be, I would suggest you need to be thinking about that. So what we do, again, it's a trust. It's a trust that treats the property as having been given away for Medicaid purposes. That's the program. You get Social Security, Medicare, Medicaid. Medicaid pays for long-term care. Medicare pays for immediate needs. Social Security provides income. Your mom and dad paid for all of them. You're paying for it with your taxes. Okay. That's what it is. The requirements for the Medicaid are a little trickier than the other ones. But here's the thing. If mom ever does need long-term care, if she needs long-term care, Medicaid provides at-home care, provides assisted living, provides skilled nursing. When it comes to the skilled nursing part of it, skilled nursing, right? Every nursing home takes the Medicaid. So what the heck? You're just giving up she wouldn't refuse Social Security. She wouldn't refuse Medicare. Why are you refusing the other one? And by doing it this way, because if she did need skilled care and she doesn't plan for it, then the cottage is just money in the bank as far as they're concerned. We see so many people losing the cottages, losing the family farm, losing the hunting property because they didn't plan ahead for mom or dad's long-term care. But the point is that when you do it right, oh my goodness, there's all kinds of stuff you can do.
Sure. It'll make it easy, that's for sure.
Yeah. Oh, and yeah, that's the other thing. And when you're talking about your kids, oh my God, I got a whole shtick on what you do with there's a way to, I don't want to take your whole day, but there's a whole way you leave it to the kids. All right. So that, I'm getting the high sign here. I gotta get to the commercial, but if you want to hang around, that'd be fine. If not, I'll tell you what our preferred. How many kids do you have? If I could ask Matt, how many kids?
Just two.
Just two. Okay. Yeah. So what all right. It looks like I got a minute.
Yeah, I can hang around if you want. No worries.
Yeah. Hang around because you've probably you may have seen a similar situation if you know other folks who've got cottages or hunting property. It's a fairly common scenario where they've held on to it through the family, but now they put all the kids on the deed. Okay. We had a situation, it's ongoing because mom and dad put all the kids on the deed. This was a very popular thing, less popular now, but for a while there it was very popular just to put all the kids on the deed. You think, oh, now that's my estate plan. I put all my kids on the deed. And the problem with that is you're at the mercy of the most ruthless, laziest, irresponsible kid. Now, you don't have that problem. You're single, but we'll talk about that when we get back.